Hi, welcome back to Space Thoughts. The DC Circuit of the Court of Appeals came down with a decision in Viasat versus FCC, and this is something I was talking about with involving the National Environmental Protection Act. What happened, and again, this deals with the licensing that the FCC granted to SpaceX to lower the altitude about 1,000 of its satellites to about 500 kilometers, and the Viasat didn't like it. They complained to the FCC in a motion for reconsideration that the FCC should have applied the National Environmental Protection Act, required an environmental assessment for doing this. The FCC said basically NEPA is categorically excluded for satellites. Viasat then proceeded to file suit in the Court of Appeals under the Administrative Procedures Act. Now, before I get too far into this, there's two other things I want to note. There was another group that filed under the same theory as Viasat, and that was the Balance Group, which is an NGO, and I'll be discussing them in this video as well. But Dish Network also had a complaint about the licensing in terms of spectrum interference, and they also filed an appeal with the DC Circuit. That dealt strictly with spectrum. It didn't do anything with the NEPA claim. But it was about, basically they were concerned, saying their spectrum could be interfered by lowering these satellites to a lower altitude. And essentially the court, in that case, they merged everything together and they considered everything at once, heard oral arguments on the same day back on December 3rd, 2021. And from that, they rendered this single opinion. Now, in the Dish case, they basically, dismissed Dish's claims and upheld the FCC's decision to do that, to actually license these satellites. And also, but more importantly, they denied Viasat's complaint about NEPA, and as well as the Balance Group. And it wasn't on the merits of NEPA itself, but rather what we call standing. In other words, the court determined that neither the Balance Group nor Viasat had legal standing to actually bring suit and under NEPA in the Federal Court of Appeals. So that's very significant, because this was, I hate to say it was really a procedural thing as much as it was a technical ruling that they did not have legal standing. And I've talked about standing a lot. Standing is really an important concept in when it comes to lawsuits when working with the judicial branch. In other words, you've got to have some sort of injury. And we'll look at that in a moment as we go through some of the excerpts from the opinion. What I do want you to understand is Dish Network, they had standing. They had legal standing to actually do it. So it wasn't a matter that the court ruled against Dish on grounds of standing, but rather they looked at the merits themselves. On the other hand, it was Viasat and the Balance Group that said, you have no standing. We're not going to go even further. We're not even going to talk about the NEPA claims. So what I'm going to do, I put together a slideshow presentation on some of the highlights from the opinion that I think are important, and we'll go through them now. Okay, and this is right from the opinion. For constitutional standing under Article 3, a party must show it has suffered an injury that is actual, imminent, or certainly impending. On the other hand, a speculative possibility of future injury does not suffice. In addition to pursue NEPA claims under the Administrative Procedure Act, a party must show that its injury is to interest of the sort protected by NEPA. So, just as an aside, the Administrative Procedures Act, basically when a entity files they're saying that a federal agency, when they were making an administrative decision, they did so arbitrarily and capriciously. So what does arbitrary and capricious mean? Well, basically it means when the agency made their decision, they basically didn't consider the facts, they ignored certain facts, or they basically showed favoritism to the party that prevailed, and so on. So in other words, it's basically it was just, hey, we feel like making this decision, and we're going to do it regardless of everything else. And that's basically what arbitrary and capricious means. And under the APA, what the court does, it reviews the record and the testimony and the decision to see if really there was whether the administrative agency actually made the decision consistent with the facts and with all proper testimony taken into consideration. So back to this. In other words, the court, this is basically how the court sets up the standing issue for both actually Viasat and the balance group. Now, the balance group's standing requirements are a little bit different, but we're going to talk about Viasat first because that's the first one the court goes at. Now, the court noted that Viasat made a lot of comments about this, and one of the things the FCC did that was really smart was instead of just focusing on the NEPA arguments, they went right to the jugular and went and talked about standing and basically asserted that the Viasat does not have legal standing to bring this case, and that put Viasat on the defensive instead of being on the offensive. The FCC flipped the tables, so Viasat had to respond to this and prove that they had standing, and there were three specific arguments that Viasat made in basically to assert that they had standing. One was concern that colliding Starlink satellites will interfere with Viasat's one satellite that flies close to Starlink. Now, the court looked at this. In other words, what Viasat is saying, well, we're concerned that, Starlink satellites, because they're so grouped together, will start colliding with each other and producing debris, and that debris will produce more debris, and there'll be a cumulative cascade event, and that debris will affect our one satellite that is in orbit near to the Starlink satellites. But to ground standing on the risk, but basically that is speculative. In other words, Viasat is saying this is a future harm. But to ground standing on the risk of future harm, a party must show both that the risk is substantial and that the challenged action substantially increases it. So in other words, Viasat really had the burden of showing, look, this isn't just a wild out speculation. This is actually going to happen. Here's the proof that it is going to happen. But they couldn't do it in this case, and because of that, this is really speculative. And under the idea of standing, under some of these cases, bottom line is you have to either show you've been injured or there is a future injury, and that injury is going to be imminent. And Viasat couldn't do it in this case with this argument. A second argument that Viasat made in favor of saying it had standing to bring this case was that the Starlink satellite system will increase Viasat's operating costs. And the court looked at this, and they basically, and this was kind of twofold. This falls into standing in general and standing with NEPA, that NEPA standing. Assertions that Starlink increases Viasat's operating costs are economic and outside the zone of interest for standing for NEPA. In other words, there are these little zones of interest for NEPA, and actually one of those zones of interest is economic. And what Viasat is saying, well, these cost increases that we're suffering or will suffer because of Starlink are actually going to actually fall within these zones of interest with NEPA. And the court disagreed with it. NEPA's sweeping list of interests do not include purely monetary interests, such as competitive effect that a construction project may have on plaintiff's commercial enterprise. So in other words, in a sense, what they're saying is just because Starlink is deploying these satellites and is gaining a competitive advantage, there is not an economic, that is not an economic interest that's covered under NEPA, and therefore there's no standing. So let me contrast that a little bit with an economic interest that might be covered by NEPA. Say I live in a city or a town, and the federal government decides that is going to open a federal prison across the street, or right down the road. And because it's a federal action, there has to be an environmental assessment. Well, the problem is that's going if I'm a homeowner, or if I have property, if I have commercial property, that is going to lower the value of my property. I am going to suffer a likely economic interest. More so if I have commercial tenants like merchants within my lease buildings, they may see a decrease in foot traffic, which is going to affect whether they get paid, the landlords get paid rent or not. Furthermore, the merchants within there could actually have standing on NEPA as well to sue, because this federal prison, this hypothetical federal prison they're going to open, would probably cause less business to flow through the doors, and therefore cause them an economic hardship. In that case, both of these people, the landlord and the merchants within, would have legal standing to sue in federal court. And this would, and the economic effect, because it's in the zone of interest in NEPA, would be considered in the environmental assessment. However, just the fact that Starlink is going to compete directly with Viasat's broadband services, it doesn't fit within the zone of interest in NEPA, and therefore doesn't create standing under both Article 3 standing and under NEPA standing. And again, this just these statements from the court basically just reinforce what I said earlier. Assertion Starlink increases Viasat's operating costs are economic and outside the zone of interest for standing for NEPA. We do not think that Viasat, and this goes further into Viasat's shareholders and officers, saying we do not think that Viasat or the shareholders, officers, employees, customers, suppliers, or other stakeholders can fairly be described as having personally suffered a nuisance, aesthetic, or other environmental injury from congestion in outer space. So in other words, what the court is saying, look, we understand this whole thing about, orbital debris is a concern right now, especially in low Earth orbit, especially where the area where Starlink is going to be populating in. And that is a valid concern. However, where is the injury? I mean, you basically said, well, you asserted speculatively that this could cause, cascade orbital debris event, which could damage your satellite, but you can't prove that. You can't show that conclusively if this is going to happen. And furthermore, I mean, bottom line is you as an entity, your stakeholders, your officers, your employees, your customers, your suppliers, right down the chain, they are really not directly impacted by the idea of Starlink being deployed, other than the fact that Starlink is competing directly with Viasat. And again, that is an economic interest that is outside the zone of interest in NEPA, and it is not covered, and therefore Viasat really can't claim they have standing under either Article 3 or NEPA or under NEPA. And again, this reasserts Viasat's claim the FCC's licensing of Starlink satellites is purely an economic injury beyond the scope of NEPA. And that basically was the last nail in the coffin for standing for Article 3 for Viasat. In other words, so fundamentally, the court said, you don't have standing. We're not even going to consider the NEPA claim because of that. In other words, we could go further and talk about it, but we don't have to, and therefore we will not continue doing that. So the next entity we have to deal with is Balance Group, and they brought the same set of allegations against the FCC that Viasat did. So the question is, do they have standing? And they have their form of standing is a little bit different because they're a non-governmental organization, and the court has to determine whether they have organizational standing. And here the court says to determine organizational standing, we conduct the same inquiry as in the case of an individual. In other words, that same Article 3 standard applies. Thus, the group that must show that it has suffered a concrete imminent injury from the FCC's licensing decision. A mere setback to the organization's abstract social interest is not enough. The group must prove that its discrete pragmatic concerns are being directly and adversely affected. So, in other words, but this Balance Group, is basically an NGO that is that has environmental focus, and it really is promoting an ideological viewpoint or an ideological environmental agenda. But the question is, does the licensing of the Starlink satellites directly injure the organization itself? And that's the key. In other words, how was the organization harmed by this licensing decision? The Balance Group made an affidavit, submitted to the court, basically stating, well, that we were injured because we had to deploy resources and personnel in response to the Starlink licensing, and we had to spend about $10,000 of our funds, but that's not really an injury, and it really doesn't meet the criteria for standing under organizational standing, either for NEPA or what have you, in order to bring suit in federal court. So basically, they're saying, look, you're not showing us anything here. You're not being injured. There's another aspect of organizational standing called associational standing. To assert that, an organization must have the indicia of a traditional membership association. This turns on considerations such as whether members finance the organization, guide its activities, or select its leadership. So in other words, in order to really take a close look whether this group was injured, whether this NGO was injured, they have to look at the nature of it. I mean, bottom line is, are the members directly funding it themselves, or do they receive funding, or are their members basically remote who give donations either online or by mail, and might receive it as part of a newsletter? I mean, in other words, do the members actually participate in the activities of the group, and are they directly injured by the licensing decision? Do they have the ability to manage or direct the course of the organization? And if they don't really, if they're just tertiary like they are here, basically they donate money and they probably get a weekly or a monthly newsletter, then it probably or in other fringe benefits, it doesn't meet the indicia standard, because you can't actually articulate any specific injury. So therefore, really, the balance group doesn't have standing as well. So I'm just going to contrast this a little bit, and just stop sharing here. I'm going to contrast this with say a suit that's going on right now. Camden County Spaceport received its license back in December, spaceport license, and there are two NGOs and actually 2 or 3 NGOs that are actually challenging to get the license overturned in the District Court of DC. And basically, these groups, they're all non-governmental organizations, but unlike the balance group, they have discernible interest. In other words, their membership has discernible interest. One is a group called 100 Miles, which basically is looking at protecting beaches for, is comprised of people who live near the beaches in Georgia and want to protect those beaches. The other 2 are homeowners associations, in the area of where the spaceport's going to be located. And of course, they're property owners. And the idea is, well, if these rocket launches start off, there is a foreseeability that, these things could go wrong and their property could damage. In other words, they could actually incur actual tangible injury. And it's not something that's speculative, it's something that could really happen. So in this case, because the members are directly involved in the organizations, because they have a direct interest and the potential for direct injury, they have standing in federal court to do what they're doing right now, which is basically trying to overturn the license that was granted for Camden Spaceport, which is a topic of another video once things start moving in that, because it's really just getting started right now. So bottom line is, both Balance Group and Viasat were knocked out of the game because of standing and the FCC license hold. The NEPA issue wasn't even considered because of this. And, of course, my opinion is that NEPA doesn't apply to outer space anyways. It's uncertain how the Court of Appeals would have responded or ruled on the NEPA complaint, just because, well, it would have been interesting to see it. But I still think in the long run, NEPA would have been found not to apply to outer space. Question is, where does this go from here? Well, there's a possibility these groups could, Viasat or the Balance Group could try to apply for cert, writ of certiorari for Supreme Court to see if they'll review the case. And that isn't a given. The Supreme Court has the option of turning things down. However, even if they did, the issue that the Supreme Court would rule on would just be the standing issue. And so let's say hypothetically the Supreme Court accepts their case and they rule on the standing issue and say, no, the Court of Appeals got it wrong. You do have standard. We're going to send it back down to the Court of Appeals to actually deal with the NEPA issue. And then afterwards you can come back and if we'll go from there. So 2 things could happen here. One, they could say that, we're just going to rule on the standing issue and send it down. Or the Supreme Court could say, you know what, we got this here. We're the number 1 court in the country. We're at the top. Even though the issue of NEPA was not decided at the appeals court level, we're going to take on our own accord what we call sua sponte to actually address the NEPA issue and see. And I think one of the arguments that will come up is whether NEPA applies to outer space, and I don't think it does. And I've had reasons for that. However, the court recently made a significant ruling, West Virginia versus EPA, and I did a video about that a couple weeks ago that you can go back and look at. And I think in light of what my legal opinion about NEPA and the ruling in West Virginia versus EPA, I think the court would say no, NEPA doesn't apply to outer space. So again, we went through all this litigation, and we pretty much still at the same question whether or not NEPA applies to outer space. Again, like I said, you know where I stand on this, and I stand firmly on it. I won't say why, obviously, because it's one of those things that are still, in the works, I think. But the big issue is, how is this going to be addressed from now on? I think we've seen right now that companies like Viasat, NGOs like the Balance Group, they're just not going to be able to get past the standing issue. Standing is going to be a big impediment for organizations like this to actually get it into court and actually address the NEPA issue. I think even on a declaratory judgment, whether if they were trying to say, well, we want to make a declaratory judgment, I don't think either of these groups or groups similar to them have standing to actually get that far. There might be, I'm not saying there are other groups out there that might be able to get past the standing bar and actually get this litigated. However, for this particular licensing of satellites, the lowering of the altitudes, that's over. That's pretty much done. The time has passed, I think, to actually do any more, and for another group to come in and actually do anything on it, because in order to get to the appeals level, you've got to go through administrative remedies at first within the agency. Then you can go to the Court of Appeals and the court system in general. So I think fundamentally, as far as using the courts to, force NEPA onto outer space, or to at least litigate it there, I think that might be pretty much done and over with. I think this ruling might have crushed it. I could be wrong. It's entirely possible. So I guess where does this go for here? I don't know. Starlink isn't stopping anytime soon. I think we saw with that motion to stay that Viasat tried to get into effect a few months last year. That failed miserably, and they've been launching I've seen at least almost a launch per week now of satellites. So this is pretty firmly entrenched. Now, interestingly, even if NEPA applied to outer space and applied to Starlink, there's a little nuance. Things have changed a lot since this initial license was granted and this suit was filed. And in particular, the war in Ukraine. And what happened in Ukraine is Elon Musk basically sent a bunch of ground stations for Starlink there, so Ukrainian forces and the civilian population could have continued access to the internet. But these fundamentally, it went beyond using email and web surfing. Basically, the Ukrainians have been using this for command and control, and I think even reportedly to control drones in some case through Starlink. So that proved a very useful national security utility, and the Pentagon here took big notice of the utility of Starlink, and the Chinese and the Russians have, of course, because the Russians have been trying to hack it. And the Chinese have made a lot of fire lately about looking for a way to disable or destroy Starlink. So they understand the national security value. So why am I talking about this? Well, during a NEPA evaluation, one of the considerations that is really looked at hard is what is the national security value of the proposed activity. So in this case, even if an environmental assessment was performed, and they came out and said, well, this is bad for low Earth orbit. However, given the current national security environment, we're going to give that a lot of weight here, and we're going to therefore we're going to permit this thing to be deployed. But again, I really don't think NEPA applies to outer space. It was a law that was created in 1969 before non-governmental space really got cooking like it is right now. And I think bottom line is, I said this before, and I said this a lot in the last video too. Congress has got to really get to work. If they want to change NEPA to apply to outer space, I think they have to do it specifically and put it specifically in there. NEPA also applies to outer space. They could amend it. That's one consideration. And actually, in light of West Virginia versus EPA, I think that's what they would have to do to get NEPA to stick to being applicable to outer space. When this whole issue came up back in February 2020, when that law review article was revealed, there was discussions. Well, obviously, lawsuits in federal court. Well, that failed. And there was also a claim. Well, we got to bring this to the International Court of Justice. Well, problem is non-governmentals, private individuals don't have standing. The ICJ is basically for states to resolve disputes between them. So in other words, standing is an impediment there too. It's an impediment not only the ICJ, but we just found out is a big impediment here for the domestic jurisdictions as well. Are there ways to address this? Starlink, I think there is. I can think of one mechanism states could use. It's interesting that I haven't heard this brought up. I'm not going to say exactly what it is. It would be an interesting assertion and an interesting move. And whether it happens, I don't know that it will, given the potential the concern about what it would mean down the road politically by opening this box and letting Pandora out. So I think bottom line is, this is a great case. I was really waiting a long time for this to be resolved. And I'm just kind of, kind of concerned about, how, where this is going to go from here, because, I've heard I've heard some people rambling saying, well, standing's an issue, we should get rid of that. Well, this is the end justifies the mean, burn it down just to get the result you want mentality. And that doesn't work, because we have a separation of powers, judicial, legislative, executive, and those have to be maintained. And the thing with maintaining is that we don't always get our way. And this is the case here. I know there are a lot of people upset about this, some organizations that are upset about this as well. But like I said, I maintain my stance. I don't think NEPA applies to outer space. I think this was a bad move on Viasat's part to really push this. And really, the only winners here are the lawyers. The lawyers for Viasat and the Balance Group, because I'm sure these things get very expensive, especially when you start employing people who specialize in appeals in courts like the District of Columbia. This isn't cheap. I'm betting. I'm just pulling a figure out of my head that based on experience, this easily at least cost Viasat $100,000, more likely more than that. So that's another reason I don't think they'll pursue a filing certiorari to the Supreme Court, because that is a very expensive endeavor. And really the payback, the return on that is not going to be as great, I think, for that. So for now, whether NEPA applies to outer space still really hasn't been resolved once and for all. But this lawsuit's out of the way. SpaceX has been very active in deploying Starlink, and I'm really curious to see what the next move will be with regards to trying to slow this down. So anyways, that's all I have for this video. Stay safe, stay healthy. Today is the first day of meteorological fall here in the northern hemisphere. Winter's on its way. I'll talk to you next time.